Okay, greetings everyone. My name is Chiza Julius and I am among the founders of Northern Law Initiative. So Northern Law Initiative is a program which is aimed at sensitizing the general public and the students community about the different aspects of law. So we are going to be discussing different principles of law, and this will be for the benefit of the general public and the students community. So today specifically I'm going to discuss the aspect of Buganda Agreement and the constitutional history. But before I dive into the aspect of Buganda Agreement, I want to give you a brief background of constitutional history and why is it important for us to study constitutional history. So constitutional history is all about studying the background of the constitutional framework we have as a country. So you know very well Uganda is a country which follows constitutionalism. So constitutionalism simply means like our aspirations as people have been put into writing, or it is that one document which governs the aspirations of the people and then how people relate with others, which is the constitution. And in Uganda, the constitution is the supreme law of the land, which one can call a grand norm. Like it is the supreme law, it is the law which validates all other laws. That's why we call it a grand norm, which is the constitution. But the constitutional framework we have, the one which respects rule of law, the one which respects democracy, the one which respects human rights and separation of powers, did not come out of the blue. There is some history behind the constitutional framework we have currently, and it is important as students of law to cover the historical background of our constitutional framework, and that's why we cover constitutional history. So when you start talking about the constitutional background of Uganda or the constitutional history of Uganda, one of the main key or significant events, all matters you are supposed to cover, is the Buganda Agreement. So Buganda Agreement, why do we cover it under constitutional history? So right now in Uganda we have a constitution as a supreme law, but now that constitution was first received in different forms. So the Buganda Agreement, whereas it was binding only Buganda and the protectorate government, it was the first form of written document we received in Uganda in form of laws, all in form of telling people what they are supposed to do and what they are not supposed to do. So that one makes it relevant for us to study Buganda Agreement. So what is Buganda Agreement? So Buganda Agreement, what we really need to know is the agreement which was signed between Buganda Kingdom and Her Majesty's government. So what do you need to know about Buganda Agreement? You need to know its background, and the background entails when was it signed and who signed that agreement and how many clauses or articles it had. So Buganda Agreement was signed on 10th of March 1900, or what we call 1900. That is when the Buganda Agreement was signed, and it was signed between Sir Harry Johnston on behalf of Her Majesty's government and Sir Apollo Kagwa, Noah Mbogo and Mr. Stanislas Mugwanya, and these were the regents of the Kingdom of Buganda by then, and they signed it on behalf of King Daudi Chwa, who was an infant, just 12 years old by then. And now Buganda Agreement had 22 clauses or articles, and I'm going to discuss the main articles which were in the Buganda Agreement. And in our of discussing them, I'm going to relate how the Buganda Agreement influenced or impacted the constitutional, political, and economic development of Uganda from 1900 to date. Now, I'm going to start with Article 1 of the Buganda Agreement. And Article 1 of Buganda Agreement provided for the demarcation of the boundaries of Buganda as a kingdom. And now, what is the implication, or what can be the rationale of the demarcation of the boundaries of Buganda? So by then there was what we call all what used to be expansion policies. So regions just used to just expand. If you had power, you expand and your territory becomes big. So in our way of doing that, of demarcating that this is where Buganda Kingdom, this is where you stop, it was aimed at stopping the expansionist policies of Buganda Kingdom, because Buganda Kingdom was a powerful kingdom, so it used to always be expanding. And now of explaining this specific provision or article, one can merge it with Article 9, that after demarcating the boundaries of Buganda, they went ahead and further divided Buganda into 20 counties. And while dividing Buganda into 20 counties, they gave 2 counties which belonged to Bunyoro, and they gave them to Buganda Kingdom. And this later shaped our historical and political development in a different way. For example, this resulted into the Kazaraine versus Luchiko case. And what is it all about, Kazaraine versus Luchiko case? So Kazaraine Joseph was from Bunyoro Kingdom, and Kazaraine, after attaining education and being civilized, Kazaraine went back and mobilized the people from Buyaga and Bugangais not to pay taxes to the Buganda chiefs, because that territory belonged to the Bunyoro Kingdom. Then as a result, Kazaraine was arrested and was brought before the Luchiko, or the Buganda court. So one can say that it was due to the demarcation of the boundaries of Buganda which resulted into giving 2 counties which belonged to Bunyoro, the one which resulted into the development or the coming of that case, or what we call a conflict between the Baganda and Banyoro by then. Then furthermore, the demarcation of these boundaries resulted into what we call the Kabaka crisis. But before now the Kabaka crisis, we had what we call the referendum in 1964, and I hope you guys will cover that. In 1964, we reached an era whereby the people in Buyaga and Bugangais wanted to be part of Bunyoro. There was an issue which was always raised in all the meetings, and even during the making of the 1962 constitution, the same issue was raised by the representatives from Bunyoro, that you gave these people a territory which belonged to us. So during the 1964, by then Obote was the prime minister, they chose to organize a referendum. A referendum is like an open vote. They go to the ground, they ask people about their views. And now when a referendum was organized, people from Buyaga and Bugangais voted to be part of Bunyoro, not Buganda, which Buganda objected, and resulted into the clash between the central government and the Buganda government, which resulted into the Kabaka crisis. But all this, the error was made during the making of the 1900 Buganda Agreement, which made the 2 counties of Bunyoro to be given to Buganda. Hope that one is very clear. Then Article 2 of the 1900 Buganda Agreement provided for Article 2 of the 1900 Buganda Agreement provided that the Kabaka and his chiefs were to forfeit their right of collecting tributes from other regions. So years back, when a kingdom or a region, when a region like annexed another region or kingdom or something like that, they are supposed to start collecting taxes from that area. So Buganda was doing the same to some of the neighboring regions. And when the colonial government came, in the signing of the 1900 Buganda Agreement, in that agreement they agreed that Buganda will stop collecting taxes from those areas. And now this article can also be merged with Article 4, because under Article 4 they said that all taxes collected from other regions were to be merged with the taxes collected from Buganda. And what was the implication of this? The implication of this was to weaken Buganda economically, like to take away the economic stability of Buganda Kingdom. And hope this one is also very clear. Now I'm going to go to Article 3 of the Buganda Agreement, which provided that the Kingdom of Buganda shall rank as other kingdoms. Like Buganda will be like all the people of Buganda, the people from Buganda will be equal with people from other regions. The kingdom will be treated equally with other regions. And how did this impact the development of our constitutional history and politics? So this brought in a question of the position of Buganda in Uganda, because Buganda Kingdom by then, they assumed that special status, that they were supposed to be special. And in a way of making them to be equal like other kingdoms, they kept on opposing this. And till now, I think you can hear some people talking of federal, that we need our federal, which means like Buganda wanted to govern, they wanted to govern themselves. They wanted that special status from other kingdoms, which now was watered down by the Article 3 of 1900 Buganda Agreement. And because of this article, Buganda kept on demanding for their special status. And even in the signing of the 1962, during the signing of the 1962 Constitution, the same issue was brought out. Hope this one is also very clear. But still, one may also say that it is important to note that the framers of the 1995 Constitution brought the idea of equality before the law from the 1900 Buganda Agreement, or from Article 3 of the 1900 Buganda Agreement, because Article 21 of the 1995 Constitution also provides for equality before the law. Hope this one is also very clear. I talked of Article 4, so I'm going to skip it and go to Article 5 of Buganda Agreement. So Article 5 of Buganda Agreement was like, laws made by the Protectorate were going to be applied to Buganda. So what was the implication of this article? That laws made by the Protectorate, which is the colonial government, were to be directly applied to Buganda. So here they are trying to show Buganda what kind of laws, or this article tried to show what kind of laws are going to be applied here in Uganda. And like this was like more of a reception, like Buganda agreed to receive and apply all colonial laws. And later we saw the conflict which came out of this, because this was also an extensive article which brought in issues like a matter which arose from the case of Mukwaba versus Mukubira, where there was a conflict between the provisions of Buganda Agreement and the laws of Her Majesty government. But then here they ruled that Her Majesty's government was not subject to the provisions of Buganda Agreement. So Article 6, like, Kabaka was to be respected and recognized as a king, provided that he respected the government or the protectorate government, or what we call Her Majesty's government. So here was like they are trying to put restrictions on Kabaka, or like they are trying to weaken the powers of the king by then, because they are like the king can only be recognized as a king if at all he respects Her Majesty's government. And this we saw in the 1953 to 1955 when Kabaka Mutesa had issues with Sir Andrew Cohen. He was deported to UK. Now Article 7 is just about the Namasole of Buganda, and she was supposed to be paid that annual sum of money, but it was only for her, not for another coming Namasole, and it was to be given to her during her lifetime. Then Article 8, it was all about the cases which involved the natives to be determined by Buganda courts, but cases which involved the non-natives were to be determined by the protectorate or the colonial courts, if I may say. Now Article 9, I talked about it. It's one which talked about dividing the counties, Buganda, into 20 counties. Then Article 10, it's about appointing of 3 ministers. And now the king here had to appoint the prime minister and also the treasurer. He had to appoint 3 ministers, the king, and these ministers were to help him administer the Luchiko and the kingdom, because each county had a chief who was representing it in the Luchiko. And till now, the president has the powers to appoint the vice president, to appoint the speaker, and to appoint the prime minister, of which one may say that the idea of appointing now ministers under Article 113, 118 was bought from the 1900 Buganda Agreement. Then Article 11 provided for the Luchiko. Now the Luchiko is like the current parliament of Uganda, but the other one was for Buganda. And right now Buganda still has that Luchiko. So this Luchiko was supposed to make laws for the good governance of the kingdom. So one may say that the framers of the 1995 constitution brought the idea of creating the parliament, or empowering the parliament, or granting parliament power to make laws from the 1900 Buganda Agreement. Hope this one is also very clear, because we see under Article 79 of the 1995 constitution, the parliament is the one with the power to make laws. Hope this one is also very clear. So 12 was about taxation, which is not so crucial, but still you need to understand it. Then Article 13 was about military service. So the king had to appoint people, able-bodied men, to offer security and to guard the community. So I hope that one is also very clear. Then I want to go to Article 15, which is an important article, and everyone must know this article and get a deep understanding of it, because this article provided for Article 15 of the 1900 Buganda Agreement, provided for the division of the Buganda land into 2, Milo land and Crown land. And Milo land, part of it was given to the king, that was the 9,000 kilometers. Then another part was given to the Another part was given to, like, each chief got a part, or like got a share on the land, which was in the chiefs were given part of the land, and then clan heads and peasants were not given land. But remember, the land which was given to the chiefs, the king, and other people, it had people, all what called natives, people who were staying on that land. And now this land was given to these people as landlords, and they are made landlords over this land. And now this resulted into a lot of issues which shaped our political and constitutional development. For example, in the 1920s, we had the Busulu and the Mvujo issues, which resulted into the enactment of the Busulu and the Mvujo laws. And now, in a way of allocating land, it's only the chiefs, the king, and Namasole and the king's family. They are the only ones who got land. Then other people didn't get land. And then these other people were subjected to Busulu, or what we can call like land tax, if I may say. And this created a lot of issues, resulting into the Bataka grievances, Bataka and peasant grievances in the 1920s, and up to now, the 1995 Constitution still recognizes the aspect of Milo land tenures. And in Buganda, right now, we still have issues. You find someone has a land title as a Milo land owner, but there are people who are staying on his or her land as Bibanja holders. So there are still conflicts which are happening and issues which are happening because of the mode of land ownership which was created during the signing of the 1900 Buganda Agreement. That's all about the 1900 Buganda Agreement. And the questions which they usually ask about it, their questions usually ask for the impact of the 1900 Buganda Agreement on the constitutional, political, and economic development of Uganda. They can ask to date, or they can ask up to 1995, all any, but they ask to date, or like they want the impacts of that agreement on constitutional, political, and economic development of Uganda. Thank you so much.